Hello, welcome to attempts or preliminary offences or inchoate offences as part of criminal law. You might see them called by a number of different names, but they all mean the same thing. So this is where a person has attempted to commit a criminal offence, but for a few different reasons that they didn't actually complete the full offence. So it could be, for example, that they had a change of heart and abandoned their plans, or maybe they were caught before it could actually be completed. There's a few different reasons it could be. It used to be an area governed by common law, and there was a number of different common law tests, but now it's been simplified by Section 1.1 of the Criminal Attempts Act 1981. And what that did was it kind of clarified what has to be proven in order for a person to be charged with an attempted crime, like attempted murder. So you need to know the actus reus and the mens rea for attempts. It's less important for you to know about the full offence, although in some instances it's important to understand what would have to be done to complete those offences. So the actus reus of an attempted crime is that the defendant commits an act which is more than merely preparatory to the commission of the offence. So just a couple of things to unpick there really. So first is that this has to be an action. It doesn't include omissions. So they must actually do a positive action. And that action has to be MTMP, more than merely preparatory to actually committing the offence. So if it's just mere preparation, that will not be enough. So that's kind of the initial setup stages. And what the courts have done through various cases is they have tried to discuss and apply that distinction. So at what point do we go from it being mere preparation, merely preparatory, to more than that, more than merely preparatory? And in other words, they're actually attempting the crime, not just preparing to attempt the crime. So we've got kind of different stages going on. Preparing to attempt the crime is not an offence. Attempting the crime is, and of course completing the crime is as well. So I think the most important case that we can use here is the case of Geddes, and I kind of call it the Geddes guidance. The alliteration helps me remember that. So Geddes talked about the move, where a person moves from the planning and preparation stage to execution, or trying to implement your plan, actually trying to do the crime. And again, we've got a couple of other phrases that we can use here. So where the defendant starts embarking on the crime proper. And for some reason that makes me think of a ship. When you embark on a ship and the ship's called the crime proper. So when you actually get on the ship and you actually start to attempt the crime, you actually start to try and commit it. And we also have this phrase of crossing the Rubicon being a river. So we actually make that step, that sort of almost no looking back. I've actually started to do something now. Signs that a person is maybe still in the planning and preparation stages, I would argue, is usually where a person is maybe just equipping themselves, or they're positioning themselves for the crime. So for example, going to the supermarket to buy a weapon like a knife wouldn't be an attempt yet. It's simply equipping yourself. And we'll also see in where, positioning is not enough. I think this is most clear when you look at some of the key case examples, and you can sort of split them and try and understand why it was more than merely preparatory or just merely preparatory. So at the bottom here, I've got 5 cases where the court said that these were attempted crimes because the defendant had done actions which were more than merely preparatory. So in the case of Attorney General's reference number 1, the defendant had dragged the victim kind of off the streets and into a building. He'd lowered his trousers and essentially started to interfere with the girl. He was charged with attempted rape because it was clearly more than just planning and preparing for a rape. He was executing and implementing his plan. And let's face it, he would have had he not come across operational issues. In the case of R versus White, clearly he was attempting murder. Now, he'd moved from the planning and preparation stages by putting the cyanide in her bedtime drink. So he'd moved from the planning and preparation stages, which would have been, you know, buying the poison or preparing the drink. He'd actually moved to executing his plan by giving her that drink. And the only reason that she didn't actually drink it, and the only reason he didn't murder her, was because she had a heart attack first. Otherwise it would have happened. So we've got a definite kind of moving along. Now, you know, you could argue, well, he hadn't completely crossed the Rubicon. You know, he could turn back because he could just pour the drink away. But the court said that that was definitely trying to execute his plan of murder. We've got the case of Boyle and Boyle. Burglary ones are quite interesting, and the key to remember is you have to understand how burglary really works to understand attempted burglary, because remember, we do have section 91A burglary, which means that you're guilty of the actual offence. You're guilty of the crime proper if you enter a building as a trespasser with intent to steal, commit criminal damage or GBH. You don't actually have to do any of those things. So for section 91A burglary, all you need to do to be guilty of the proper full crime is to enter as a trespasser with one of those things in mind. So the attempted stage is essentially attempting to enter, because once you're in, that's the full crime. So in this case, where Boyle was found next to a partly broken door, that was clearly an attempted crime, because if you think about it, the execution, the completion would have been going in. So that was clearly more than merely planning and preparation. Similar with Tosti as well. So he was a bit further behind. He was found hiding in bushes and had checked the lock. The court said again, that was a bit more here. Even though he was putting himself in position, and even though you could argue, you know, he hadn't broken the lock, he was just checking it. What were the next stages? What would have been left to complete here? It would have been breaking the lock, going in. And the court said, you know, actually he started to commit the crime by where he was and what he was doing. Perhaps a bit of policy there, of course. You know, should this person really be getting away scot-free? Finally, we've got the case of Jones. Well, he was charged with attempted murder. This was clearly more than planning and preparation. He got into the man's car, the sort of new boyfriend of his ex. He got into the guy's car and pointed a gun at him. I mean, how many more stages were left before the crime was complete? You know, pulling the trigger is essentially what was left. He said he had the safety on, but we're talking very minimal steps here before the crime's actually complete. So these people were more than merely preparatory. In terms of mere preparation then, what would you have to do for it to be those initial stages and not yet an attempted crime? The case of Gulliver, he'd only jumped onto the track. Now, he was trying to disrupt a race because he wanted to get his stake back. But the court said he still had a number of steps to go before completing the theft, because essentially the theft is going and getting the money back. So even though he just jumped onto the track, there was still a number of other stages, you know, going up to the betting window, etc. So hadn't really embarked on the crime proper yet. He'd just done the planning and preparation stages, interrupt the race, and then the rest of it was really going to come when he tries to go out the window to get the money back. Geddes, again, this is a really difficult case to potentially understand, I think, and certainly it sort of goes against policy. Geddes was found hiding in toilets in a school, and he had the equipment on him to abduct a child. Clearly, this person was intending to kidnap. But the court said here that he was still in the planning and preparation stages. And in the most pure sense, he had the equipment with him. He was in position, but he hadn't left the toilets yet, which they felt would be those would be the stages of embarking on the crime properly, to actually go and attempt to speak to a child and attempt to take them away. So there was still a number of stages again. They were simply in that stage. They hadn't moved across yet. In the case of Campbell, so this is slightly different to burglary. He was going to commit robbery, which is of course committing theft with force or the fear of force. He was stood outside the post office. Now again, he had the equipment, he had a fake gun, he was in position to go in, but there was still a number of steps, so he could have just walked off. There were still a number of steps to complete involving going inside, speaking to the cashier, making the threats, etc. There was still a number of steps before that would have been completed. There's also an additional case as well, Nash, which is where a man had sort of tried to get children to commit acts of gross indecency, but he'd sort of sent them letters, and again it was felt that that was still planning and preparation. There were still a number of stages that had to happen and would have had to happen for him to be guilty of a full offence. So once you understand the kind of difference between the two, if it comes to an exam scenario, what you need to look at is how far along the scale of the crime are there, how many steps would have been left essentially to potentially complete this. Do you think that it is still just mere preparation, that they are still in the planning stages, they are still getting stuff together, they are still getting into position? Or do you feel actually they've sort of crossed that line, they've crossed the Rubicon, and they're now actually starting to do the crime properly? You know, they're trying to implement their plan, they're trying to execute what they want to do. So you really got to look at kind of what stages have they done, what stages would be left, where do you think they are in that sort of moving across. They must also, of course, have the mens rea. So the mens rea, quite simply, is that they must have intended to commit the crime when they were doing the acts that were more than merely preparatory. So the law has been quite clear that this includes intent only, not recklessness. Millard told us that. So they must have intended to commit the crime. The only time that you would talk about recklessness in attempted crimes is if it's part of arson. So there's an offence which is arson with recklessness to endanger life. That would be allowed, but again, I think that's a bit misleading, because surely they would have to intend the arson. That's where the intention still comes in. And the case of Attorney General's 3 of 1994, they told us this rule does count. But remember, that person would have to show that they, the prosecution would have to show that person intended arson still, but they were reckless as to whether they would also endanger life as part of that criminal damage by fire. So what does this kind of include? Well, it includes a conditional intent. So if you remember the case of Esom from theft, he certainly attempted theft because he put his hand in the woman's handbag, intending to steal something if he found it. He rummaged around, but he didn't complete the theft because he didn't take anything in the end. There was nothing he wanted. That would be attempted theft, because he's definitely done an act which is more than merely preparatory by rummaging in the bag, and he had intent. If he found something, it's still intent. It also includes impossible crimes, so where a person tries to commit a crime, but they're actually prevented from doing the actus reus. That person still had the mens rea, they still wanted to commit the offence. So Shiv Puri, of course, is the classic example which changed the law. The House of Lords used the practice statement to overrule the previous case of Anderson versus Ryan. And in R versus Shiv Puri, they said that he was guilty of attempting to supply drugs. And that's because he had the intention to supply drugs. He was trying to supply drugs. It just turns out that they were a sort of harmless legal vegetable matter instead. That doesn't matter. He was trying to supply drugs and he had the intention on supply drugs. We can also see that in the more recent 2007 case of Jones, where the man thought he was attempting to, solicit young girls for sex. He thought he was speaking to a 12-year-old girl, so he was intending to solicit a 12-year-old girl for sex. He was definitely doing actions which were more than merely preparatory, because he was talking to her and he was making these suggestions, but it turned out actually it was an undercover police officer, an adult. So the crime that he was doing was impossible because the girl was not 12. It wasn't an underage person, but he was still guilty of attempting because he had the full intention. Just the last little question, I suppose, is the sort of interesting conundrum around murder. If you remember, the malice aforethought is the mens rea for murder, and that means that a person must have intent to kill or cause serious harm. And it was confirmed in the case of Wybrow that when a person attempts murder, they must have intended to kill, intent to kill only, because otherwise, if a person intended to cause serious harm and they tried and failed, that would be attempted GBH, not attempted murder. So attempted murder, they must have done an act which is more than merely preparatory, like in the other case of Jones, for example, and they actually tried to do it. They had that intention to kill. And what that means is actually quite an interesting quirk, where if you commit murder, we'll accept intent to kill or cause serious harm. There's two ways, it's a law bar, but if you're convicted or charged with attempted murder, it's one only. We must prove that they intended to kill. So quite an interesting thing. So what you're looking for here in a problem scenario is, are there signs, is there evidence that a person actually wanted to commit the crime at some point? So when they were doing the actions that were more than merely preparatory, did they have intention to commit the offence? Was it their main aim? Was it what they wanted? It's not enough for them to realise the risk and do it anyway. That would just be recklessness. They have to do those actions while wanting to commit the crime, because of course the next couple of steps would have been committing the full offence. Okay, hope that makes sense. Thanks for watching.